webinars by various members of the employment group, which focuses on practical aspects of employment tribunal litigation. For those of you watching on the 24th of November, you will receive a copy of the handout I've prepared for this after the talk. For those of you watching via the YouTube channel, there's a link in the text below to the notes. The idea for this webinar came about because I'd experienced two distinct camps of representative at the Employment Tribunal, those who embraced preliminary hearings and case management and saw them as a real opportunity for them and their clients to win friends and influence people, and those who, quite frankly, didn't. The aim of this webinar is that if you're in the latter of those two camps, to convert you. As we all know, the framework of rules for the Employment Tribunal is set out in the 2013 regulations, and in particular Regulation 2, dealing with the overriding objective, and Regulation 29, dealing with case management power. The gentleman I'm sharing this slide with is Isaac Asimov, and in 1942 he wrote a story by the name of Runaround, in which he set out the three fundamental rules of robotics. I've set those rules out in the handout. I won't repeat them here. However, I have updated them for employment tribunals, and it's with great delight that I present to you Salter's rules. And here are Salter's rules. Rule 1, a representative may not injure the tribunal process or through inaction allow the tribunal process to come to harm. Rule 2, a representative must obey orders given it by the process except where such an order will conflict with the first law. And Rule 3, a representative must protect its own existence as long as such protection does not conflict with the first or second laws. In the past, when I've presented this talk as a seminar, I've had a competition with the delegates that if they can name the 5 robots in the series that they appear from, then they would, one of them would win a prize. There is no prize for an online webinar. However, the question still remains, are you able to name the next 5 robots that appear in this talk? The first of these rules is that a representative may not injure the tribunal process or through inaction allow the tribunal process to come to harm. It consists of 3 elements. Firstly, professional pressure. Secondly, client pressure. And then finally, personal pressure. Considering professional pressure, one has to understand the world of the tribunal advocate. Many of us have obligations under our codes of conduct, and there's also the added obligation under the overriding objective to cooperate with the other side. And I think this duty of cooperation is almost enhanced by the impact of COVID-19 and the lockdown. Even before March, budgets within HMCTS were tight, backlogs of cases were considerable, and individual matters were at risk of being adjourned or stood out the list at short notice. Without cooperation, for instance, if you attended, say, a one-day hearing without adequate identification of the issues between the parties and spent an hour of your time at the tribunal dealing with that, you've used up roughly 20% of the resource the tribunal's allocated to your claim on a matter that quite simply should have been resolved earlier. This could lead to either part-heard hearings or reserved judgments, which are both things that neither party are likely to want, and certainly the judiciary don't want. Also remember that the employment judge hearing your case may have 2 or 3 other hearings that day. So, as I say in the handout, if you are the 12 o'clock case management hearing, don't send your note and agenda in at 10 o'clock that morning, because chances are the judge is otherwise engaged on another matter and won't have an opportunity to look at your preparation. A rule of thumb that I like to use is to get my note and agenda to an employment tribunal a week before the case management hearing. That way, hopefully, the documents will find their way onto the file, and when the regional employment judge is allocating the appropriate judge to the hearing, they can see exactly what you expect to be addressed at the hearing and can allocate it accordingly. Further, if your case management hearing is listed in person but you don't think it warrants such a use of resource and time and expense, then a good note and an agenda accompanying your application to transform it into a CVP or a telephone hearing goes a long way, because the judge or regional employment judge who are considering your application can see exactly what it needs to be addressed at that hearing and whether or not a telephone hearing is appropriate. Another element of professional pressure is the need for HMCTS to decrease the growing backlog of single cases. Even before the COVID lockdown, those were running at over 30,000 cases, and recent statistics show that there are now in excess of 40,000 backlogged cases. So the tribunal will look for a time estimate that gives it sufficient time to hear all the evidence, determine all the liability issues, make its decision, deliver its judgment, and also to hear evidence and submissions on remedy. This will often involve a tribunal not wishing to relinquish power to the parties at a case management hearing. I feel there's a growing reluctance on behalf of employment judges to accede to applications for 7 days, for instance, to supply particulars of claim, especially when the request was made in advance. Bitter experience shows that when parties are given that opportunity, timetabling, very careful timetabling, can go awry, with further hearings needed to be slotted in or preliminary hearings and arguments needing to be heard. An indication of the tribunal's desire to keep control over the proceedings is contained in box 2.3 and 4.2 of the agenda. Box 2.3 deals with additional information and seems to indicate that that information should be provided in advance of the preliminary hearing. Box 4.2, which deals with preliminary issues, asks whether or not the preliminary issue can be dealt with at that preliminary hearing, and then contains words, and if not, why not? So it is precious to advance hearings and get matters progressing, especially when it comes to further better particulars. I can't see a reason why those requests for particulars can't be contained within the grounds of resistance of an ET3 or with correspondence accompanying the ET3. And that way, when the employment judge who's conducting the sift of the paperwork sees the request, if they agree with your request, they can make an order of their own motion, requesting those particulars in good time and in advance of the preliminary hearing. Moving on to client pressure, I think, quite frankly, all clients want more for their legal spend, and active and thorough case management in preparation for a case management hearing can really assist in achieving that goal. For instance, with a clear list of issues, you'll be able to identify who are relevant witnesses. That has the knock-on effect of what are the relevant documents. With social distancing applied in the tribunal will want to know who is attending, at what time and on what days, and for how long. And equally, your clients will want to know which witnesses they require, if you're acting for the respondent, to be out of the business, or if you're acting for the claimant, which of their witnesses will need to potentially take time off work to attend tribunal, and on what days. An accurate and realistic time estimate also assists in bolstering your credibility before the employment judge. I've had parties attend and tell me it is agreed that a 9-witness potential interest disclosure case with jurisdictional arguments and causation arguments will take 2 days for consideration, judgment and remedy. Finally, personal pressure, we can deal with that quite quickly. There's a lot of pressure on you as a representative with thorough case management. Hopefully, the seemingly endless emails and correspondence chains passing between parties as to what the issues are can be cut down, and with, as I say, a clear list of issues, disclosure obligations are a lot easier to comply with. So here is your second robot as part of the competition. The second rule is that the representative must obey the orders given it by the process, except where such orders will conflict with the first law. There are basically 4 subparts to this rule. The first is in relation to house style. Most of the regions have their own unique style for setting out orders, and it will pay dividends to go back, look at your previous cases and see whether or not there is a house style in your particular region. If there is, then develop it and adopt it into your list of issues. Second is attempts to limit the claim. Far too often you see or you receive an application to strike out a claim that you know is not going to be successful, either because it's a discrimination case where the facts are in dispute, or there's quite clearly an arguable point to be raised in relation to the fairness of the dismissal. The case law, as I set out in the notes, makes it abundantly clear just how high a threshold it is to strike a claim out, and what the tribunal will not be willing to engage in when considering strikeout applications, i.e. Extensive poring over volumes and volumes of documents. Turning now to the list of issues. When drawing up your list of issues, remember what the employment judge has in front of them. What they'll have is the ET1, the ET3, possibly the ACAS certificate, and some internal case management paperwork. They will not have the volumes of material that perhaps you've obtained from your subject access request or that your client has provided to you as soon as the ET1 landed on their desk. You can assist the employment judge in this regard by cross-referring your list of issues to the ET1 or the ET3's particulars of claimant grounds for resistance. But obviously a lot easier if those contain numbered paragraphs. What is not acceptable is simply to have as an issue, was the claimant unfairly dismissed? break it down to go back to the very first principles: jurisdiction, include time limits, was the claimant an employee, were they dismissed, what's the potential reason for dismissal, if it's redundancy, look at the Williams and Compact Maxam issues, if it's a virtual dismissal misconduct case, go through the virtual steps stage by stage. It's very, very basic, it's very formulaic, but it does assist an employment tribunal immeasurably. So where do you find guidance in relation to this of issues? Look at the case law. Useful guidance as to the list of issues for protected interest disclosure cases can be found in Blackbank here, the Employment Appeal Tribunal decision of 2014, and for failure to make reasonable adjustments, Environmental Agency in Rowan back in 2008, updated in RBS and Ashton, although it was still a Disability Discrimination Act case in 2011. Also, how the be alert to overloading the claim form. Recently, the EAT in C versus D highlighted the need for concise and precise pleadings rather than narrative documents that simply say at the end, and for the reasons given above, the claimant's dismissal was unfair. Despite what the Employment Appeal Tribunal said in C and D, you do wonder whether or not that's realistic in light of the Tribunal's power for early neutral evaluation. Whilst it is a very underused power or little used power, the Tribunal can, if it feels it has sufficient material and both parties consent, make an early neutral evaluation of both parties' claims, highlights what the judge on the day considers to be the weak points or strong points of particular cases. However, obviously, in order for a judge to make that evaluation, they need a certain degree of material. And you wonder how you can provide that sufficient material weighed against the guidance by the EAT to keep pleading short and not in a narrative form. At the outset, I raised about adopting a house style, and whilst this is hopefully a useful point, do please be aware of adopting boilerplate pleadings. Quite often you see in, I don't know, Section 15 Equality Act claims, the respondents plead justification but don't add any meat to those bones. That stands out like a sore thumb, and often when the representative at the hearing is asked what is the legitimate aim, they have no answer, they haven't taken instructions, and so they request 7 days. Finally, do be aware that it is incredibly difficult to appeal a case management decision. See, for instance, Circuit and Wells in 2016, when the appeal tribunal said it would be very rare indeed for an appeal tribunal to interfere with a case management decision. And for those of you playing along with the competition, here is your next robot. And now we come to the third rule, that the representative must protect its own existence as long as such protection does not conflict with the first or second laws. Repeated and prolonged high-quality case management hearings means your name will get about amongst the judges in that hearing centre for being reliable, for being able to cut through the morass of information to what are the key issues in the case, and it will pay dividends. Not only will the judges, say, get to know you by name and will trust your representation at a hearing, they will also may stand as referees for you at any application that you wish to make. Also remember that case management doesn't end at the end of the hearing. Volunteer to email the list of issues to the tribunal's general email address. Email it in a Word doc format, so it's easier for the employment judge to cut and paste your list of issues into their order, rather than the PDF, which the tribunal may not have the software to rip out the relevant parts from the PDF. Finally, wine, beer, chocolate and comfort food. Make sure you don't have the sort of reputation that has the judges reaching for one of those 4 things when they see that you are representing one of the parties before them. By sustained and prolonged high-quality case management hearings, you will get a good reputation with the tribunal, and they will be able to turn to you as a rock when you are faced with your opponent who may not be quite as well prepared as you are. Finally, here is your robot for this slide. So thank you very much for attending this webinar. Hopefully there's been some useful food for thought thrown out in those last few slides. What I will do now is I will just go into my emails to see whether I've received any questions, and I'll let you know what those questions are and hopefully answer them. So just bear with me. The screen might go black for a moment or two, and I'll be back hopefully in the next few seconds. Okay, well, hopefully everyone can hear me. I apologise for the errors at the beginning of the webinar. I have received one question in relation to what constitutes a perfect list of issues. And for me, the perfect list of issues is one that has a logical progression to it, one which goes through the format of the particular claim. So an unfair dismissal claim will have, was the claimant an employee, were they dismissed? Did have sufficient continuity of employment? And then when getting to the more controversial matters, such as what the issues of fairness are and such like, gives a very, very brief, no more than a line summary of what each party's contention was. I know the claimant says they weren't called to a disciplinary meeting. The respondent denies this and says they sent letters on these dates and the claimant didn't attend. So that sort of thing I'd expect to see in a list of issues. Another point would be for Equality Act claims, and it's something I covered off in the talk itself, was about justification. It always seems to me that respondents plead justification but don't think about it, and at the case management hearing quite often just say that they don't know what the legitimate aim is, let alone the proportionate means of achieving it. So lovely. Thank you very much for your attendance today. I just check if I've got any other questions. Oh, I see I've got something's come up in the chat. I'm asked what the citation was for C and D. If you give me a moment, I'll bring the notes up. I say there is a handout, runs to some 17 or so pages that will come out, and that has the citation for C and D in. Of course, I can't put my hands on it immediately, and forgive me for looking off to my right. Oh, C and D is UKEAT/0132/19/RN and is set out in paragraph 41 of my notes. Another question came in via the chat. If you're against a litigant in person whose claim is very unclear, to what extent are you obliged to set out what you think their claim might be? That is the particularly difficult and question to resolve. When I'm in practice, I simply go as far as what I think I can safely say the claimant's case is. If it is one of two or potentially three alternative claims, I set those out just as very brief points. I don't go into any detail. The judge at the case management hearing is likely to build on that sort of detail, provided that it is contained within the ET1. There are judges, we all know, that are notoriously pro-claimant, and there are some that are notoriously pro-respondent, and I suspect it's just unfortunately the luck of the draw on the day that how far the judge is prepared to allow the claimants to build on their case. A colleague in Chambers has just asked what is the most annoying thing that a representative can do at a preliminary hearing? Any good war stories? Well, as that member of Chambers will know, because I keep bending her ear, there are a lot of war stories that I have. The most annoying thing that a representative can do at a preliminary hearing, they start arguing with the other side over matters that the judge has no control over, or say, it's not my case. Ultimately, it is your case, even if you're only instructed for the preliminary hearing and the case will go to final hearing to somebody else. You've taken on professional obligations and responsibilities towards that person. So yes, saying it's not my case when I ask a very straightforward question is a manner in which, or is pretty guaranteed to get my back up. Yes, so I think we've exhausted all the questions. Yeah, thank you all very much for your attendance. As I say, I'll arrange for the notes to be sent, the handouts to be sent to everyone in the next couple of days. And if there's a point of the talk that you'd like to revisit, it will be on Chambers' YouTube channel in the next couple of days as well, with a link to those notes if you don't get them. So thank you all very much for your attendance. I shall now call an end, press the big red button in the bottom of my screen and call an end to this webinar. Thank you.